I'm the principal of Maripol Data, and I am very proud to have these two special guests today among us. Rachel Tiller is part of our advisory network, and we have actually tried to schedule a talk for, I think, 4 years now that the project is running and that the negotiations are ongoing. So sometimes I think we are also lucky to be able to observe this process over such a long period of time, but at the same time, we all hope that this will be the last round of IGCs in the process. So we invited you to hear your voice, to know what your thoughts are on what will be happening, what has happened so far, why it has taken so long, and what we can expect from the negotiations that start next Monday in New York. So thank you very much for being here. I wish all of us a good debate, and I hand over to Ina.
Yes, thank you very much, everyone, for joining in so shortly before the BBNJ negotiations in New York. I see a few familiar faces, and I'm happy to see also some of the people that we know from the negotiations. So I'm sure there are some people already working on these issues and will engage in our discussion after this session. So for those of you still a bit new in the process, the BBNJ negotiations started a long while ago with the ad hoc open-ended working groups already in 2005, and are now going towards the end with the resumed 5th session of the intergovernmental conferences starting next week for the next 2 weeks. And those of you who have followed the process closely as negotiators, as NGOs, as scientists, will know that there has been a lot of progress, actually, particularly in the past session in the ultimate IGC 5, but there are also some issues that are still unresolved. And this is our topic today. We invited Elizabeth Mendenhall and Rachel Tiller to talk a little bit about, is the next 2 weeks enough for an equitable and effective treaty design? What are the issues to be resolved still? And also looking into liability for environmental impact assessments. So for those of you who registered, I sent around some readings on this. Who is now joining in for the new times, you can also send us an email and we will forward this to you later on. There will also be a recording available, but we will also encourage you to engage in the discussions, and are looking forward to the presentation. I will briefly introduce to you our presenters today. Elizabeth Mendenhall is an assistant professor in the Marine Affairs Department of the University of Rhode Island, where she also serves as the graduate program director. Her PhD is in international relations, and her research focuses on the drivers and mechanisms of change in the ocean governance regime. Her recent publications explore regime development in a wide range of areas, including biodiversity beyond natural jurisdiction, restrictions on nuclear transit, flag and port state obligations in a pandemic, fisheries conflict, and marine plastic pollution. Our second presenter is Rachel Tiller, a chief scientist at SINTEF Ocean in Norway in the Department of Fisheries and New Biomarine Resources. She's also the director of the key strategic research area of biodiversity and area use at SINTEF, and she has published extensively on the emergent patterns and trends in the BBNJ negotiations. Her PhD is in political science, and she has interdisciplinary experience around sustainability analysis, user group interactions, biodiversity challenges, and governance analysis. And with this, I would like to hand over to our presenters, and then we will go into our discussion. Thank you very much.
You, Ina. I am going to be the one that I see the entire screen there, Beth. There you go. I'm going to be the one starting us off here. And this was just a really, really nice introduction, and I really appreciate it. I was wondering a lot about how we were going to be introduced, and we were asked to send in a discussion, some thoughts about who we were. And I was very fortunate that Beth sent in a really excellent bio about me that I really like. So thank you, Beth. I sounded really awesome on it, and I appreciate that. We have been working on this now for a few years, as Ina was mentioning. And as you all know, probably, we're talking about a large portion of our Earth that is right now going to come under some sort of protection and some sort of sustainable use. It's been a while. I mean, we've been talking about this. We've been talking about, well, generally environmental issues since 1972, so for about 50 years. And we've also been talking about the ocean since right after the Second World War. So we have been aware that there's been issues for a while, and we have been working to try to come to some kind of conclusion about how to protect our Earth. There's a lot of other things that are going on at the same time that also have an effect on what's going on at the BBNJ process. And one of those is, of course, that at the end of last year, we did get some new biodiversity targets. We got the 30% protection of land and sea at the Global Biodiversity Framework in Montreal. And that will also have some kind of interaction with this negotiation. So what we're hoping, of course, is that 2023 is going to be the year that we do get this new BBNJ treaty. And what we want to talk about here today is whether or not these 2 weeks are going to be enough. So I will take you through a little bit of our history that me and the 3 other Elizabeths have had with the BBNJ, and get us through IGC5. And then Beth will take us through what is missing and what our hopes and dreams are for this treaty after that. So if you do the next one. Right. So everything started with us when it came to the BBNJ treaty in February 2017. So in 2016 already, we had started looking into this. We started discussing at the International Studies Association, where also Ina and Alice are members, and where a lot of us that work in the ocean affairs and international relations come yearly, really, to discuss these topics. And we were invited into the United Nations Academic Impact to a closed session to talk about this treaty and how it could work with academics. So there were 3 of us that were these international experts that were considered to come in and talk about international relations and academia and how that could work with negotiations such as this one that was going to be starting the next year. So the ones that were meeting at that time, there was me, and it was Elizabeth Nyman, who was one of our co-authors, and Elizabeth DeSanto, and another colleague of us called Aslaug Asgeirsdottir. And at that meeting, when we were there discussing how were these negotiations going to be taking place, what was going to be happening to them, and what were our vantage points as academics, we met Beth, that's here, Elizabeth Mendenhall. So she was also at that meeting, and we were all there to basically follow this birth of a treaty, watching it start from the beginning. And I felt that we were in a really fortunate spot that we were able to come in that early. And of course, as Ina also mentioned, the working groups and the preparatory committees had already worked on this for more than 10 years at that time. So we didn't come in at the very earliest time. We did come in 2017. So you can do the next one. So in 2018, that's when we first went to the first IGC. And it was all 4 of us. It was me and the 3 Elizabeths, as we sometimes call ourselves when we want to make it easy for ourselves. And we did participate at these NGOs, as we have throughout the entire process. We participated through the International Studies Associations. So we're there through their accreditation as an NGO. What our role has been there during all these negotiations is that we've been doing a lot of interviews with different, both delegates, with NGOs, and with other participants and observers there. And we've also been taking very thorough notes that we've been organizing by country at a later time. So we've been building up this sort of database of who says what at what time at all the IGCs, and we've been coding it based on the different IGCs and gender and all these different ways of coding it. We've been basing our information in our articles on these coded narratives, basically from the negotiations. And for those of you who wonder, it has gone through GDPR, it has clearance, but there are some elements of it, as those of you who are participating it would know, and those are the informal informals. So because of that, we are still unable to publish the database in case you were wondering if you could have access. But it's been anonymized in all our articles. If you can do the next slide, yeah. So in all our articles, we have basically written one article from each of these negotiations. Now, this is just a picture of one of my favorite delegates. Others have different delegates that they are favor. I always take pictures whenever the Russian delegates come on. He talks a lot. He has a lot of opinions. It's very exciting. Everybody in the room usually just like sits up a little bit straighter when he's going to talk, because you never really know what's going to come. Lately, we've been starting to know what's going to come, but it's generally something that seems to be a lot of people want to hear from what the Russian delegates are saying. Obviously, it's been a little bit more tense the last couple of years, but it's been a really really good ride with all of these. So obviously we've written a lot of articles, and we've written a series of articles. It's what it's become in the end. So one from each of the different negotiations. You can see them there on the left side, where we basically track the treaty negotiations throughout all of these negotiations. So the overall research question that we've had throughout this whole section is to it's centered on the different factors, right, that explain the prospects for designing this final BBNJ agreement and how we're going to design it. On the first, during the first one in August 2018, that's the article that's on the top there, that we called the Once and Future Treaty. In this one, we concluded basically that BBNJ seemed to be the driving positions more than biodiversity, right? Beyond national jurisdiction was what people were talking about. That was what we were focusing in on. And during the second one that came about 6-7 months later, in March, April, in the spring of 2019, we looked more into how the current ocean governance regime was either stopping or enabling the new BBNJ agreement, right? I mean, what was pushing it forward or hindering it coming to terms? And the reason for that was because this should not undermine element seemed to inhibit a lot of movement towards consensus at that time and towards making it an effective instrument. So that was like the time where do not undermine was really big. So then when we came to the third round, which we call stuck in the middle with you and not much time left, at that time, we were guided by draft treaty text finally. So at that time, we finally got something to look at. But at that time, they seemed to go back to something that was really big in the first meeting, and that was the common heritage of mankind and the freedom of the seas. They tried to set them aside in the second one to get less polarization, but it still seemed to be basically the main thing driving it. So I felt like we were taking steps backwards again. So the fourth meeting, because the third one was in August 2019, so naturally the next one was scheduled to be in 2020, around March, April in 2020. But for natural reasons, as you know, this was not going to come to terms, and it was pushed ahead because of that. So the IGC4 took place in person in March, April 2022. But because of the continued pandemic restriction, there were still limitations. There was only 2 persons per state delegation. There were no observer participations allowed. And it was like this lowest common denominator feeling that we called it, because there was a lack of political will. And you got to know, though, in between here, there was a lot of stuff going on. There was a lot of talks, there were a lot of discussions, there were a lot of different coalitions talking to each other. Now, Alice and her group have published on that, which is really good publications. And I really encourage you to read those if you've not done that. So then if you can look at the next one. During the fifth one then, so at this last one, that was just recently in August, there was these two, no, in September, I don't remember right now, but it was these 2 weeks that was really, really warm. It was really intense. And people came there being, I don't know. I was really, really positive. I'm always really positive. Beth didn't think we'd get a treaty. I totally disagreed. I was completely convinced we would, because that summer there had been so much talk about how we needed to get it. There was so many during the Ocean Week and during these big events, everyone was saying we will get a BBNJ treaty this year. This year we're going to get a treaty, and we did get some steps forward, right? So we did get this draft treaty text before, and then we got an update at the end of the week, and then we got another update over the weekend. And if you read our latest article that we called "Shake It Off," we do talk a lot about word count and how you can see that they have reduced a lot of word counts. There was a lot of word reduction in the treaty texts, but it wasn't really enough reduction for there to be any real movement. And I remember on the last day when we got the last treaty text, that was the first thing Beth did. She immediately went for the word count, and she saw in several places things had gone up. And then what we also saw was the word shall, which makes it a lot stronger. That was reduced overall during the 2 weeks. And the word putting them in brackets more than doubled. And that showed there was a lot of disagreement about how strong this treaty language should be. And it seems like they might be weakening the obligations in the text a lot. So even though there were some concessions that were made during this week, the most updated version in the end there still had a lot of brackets. So the hope was like dimming really a lot. And we sat there for so many hours that night, just waiting and hoping that maybe all these extra meetings that were going on the side was what was going to push us over the edge and actually get to an agreement. But in the end, I mean, this picture you see right here is Samoa talking on behalf of the SIDS, and it was a really rough moment, really, for all of us. It was really late at night. I don't even remember how late it was, but it was super late, and she was telling us about how much money they had spent in the SIDS on going to New York for 2 weeks with their delegates from all these different islands. That was money that could have been used to build roads, or build schools, or build protection against rising sea levels, right? They were spending that money, and they came there and they had promised their people that they would come home with an agreement. And it was a really, really, I can't even come up with a word. I was crying. Everyone was crying. It was really rough. And really, really quite sad. If you do the next one. So in the end, though, I mean, basically there was no consensus. There was a lot of disappointment. People were expressing their disappointment very clearly. The reason why I have a picture here of the delegate from Micronesia, though, first off, I just want to say this is a picture from IGC4, and you can see that because it's an online photo, because there were no pictures of him from IGC5. But I just wanted to show you him because it does make sense. So when she announced that basically they were done, we have to resume it at different dates, pick up where we left off. He, in his closing statement, then what he said was like, I'm quoting here, it's like, we're not having another IGC, he said, we're having an IGC bis, so you better hold on to your little octopus. And then by that he was referring to, if you see right in front of him, there's these little knit octopi that are sitting there. And there was the delegates by the High Seas Alliance of NGOs that had decorated the desks throughout the IGC negotiations ever since 2018. It's really been a nice negotiations in that way, really good atmosphere. Iceland also had a really touching, good, strong final statement. So made people, feel a little bit better after that really emotional statement by Samoa and the SIDS. And that's why we called our last paper "Shake It Off," because because at that point it was like, okay, we have to shake this off, we have to move on and sustain the positive momentum that they had reached at the end of IGC5, so that we can have these resumed talk, right, that are coming up. And the term BIS that they're using by saying that we're having an IGC5 BIS, it's used in the drafting of the treaties to indicate there's going to be another version of the text. So in this case, it refers to an addition that is made to it, but it's still connected to the last one. So what we need to know now, though, is like, what are we going to need for a new treaty to actually be adopted in the next couple of weeks? And that is what Beth is going to take us through right now.
Thank you so much, Rachel. And I should warn everyone that the whole time that Rachel was talking, I was just drinking more and more coffee. So I'm very ready to go. So if we want an effective treaty, one that achieves the goals of conservation and sustainable use in an effective and efficient way, we need these three things. We need a treaty that's done, a treaty that's designed well, and a treaty that's fully implemented. And in my opinion, there's been a lot of focus from the larger BBNJ community on getting a treaty done. And as you see in these recent articles by Christina Giardet and her collaborators on the right, a lot of focus on getting the treaty implemented. But I personally am still very caught up on the design of this agreement. And if the agreement is not well designed, then even if it's finalized and even if it's fully implemented, it won't be effective at achieving those larger goals. So this slide is a summary based on the most recent draft text of the agreement of major remaining areas of disagreement. And I'm not going to discuss all of these, but I want to start by offering kind of a cautionary note about using this as a representation of how far we are to the end, or how close we are to the end, rather. Because at the end of IGC5, there were a lot of concerns expressed about the most recent draft text, the refreshed, revised draft text, seeming to represent consensus that hasn't actually been achieved, because it reflects the work coming out of the small homework groups. And so I think that it's possible that we will see, especially regional coalitions, coming to IGC5 plus or IGC5 bis and saying, listen, this part of the treaty that seems settled, it's actually not, because we didn't have a chance to comment on it and we have suggestions for it. So I think it's possible that we see a reemergence of brackets and suggestions of new articles in relation to the current refreshed draft text. That being said, these are the major issues that are remaining in this draft text. And I just want to highlight a couple. On the level of principles, I'll talk about common heritage more in a minute. This question about precaution is really just an issue of phrasing. Right now, the draft text says application of precaution. Some prefer precautionary principle or precautionary approach. And certainly the phrasing has different meanings in terms of what concept is incorporated in the treaty. But the fact that it will be included as settled, it's just a question of how it will be phrased and how it will be conceptualized. On marine genetic resources, probably a lot of you are familiar with the debates over utilization, whether it should be prescribed to a particular purpose of serving the interests of all humankind, whether or not there should be requirements for monetary benefit sharing associated with utilization and commercialization. But I'm particularly concerned about Article 12 on intellectual property rights. Right now, it's been pared down to very little. I think it's 1 or 2 sentences. And it says the BBNJ agreement must be mutually supportive and implemented in a consistent manner with the WTO and the World Intellectual Property Organization. In my opinion, that is submerging a real set of issues related to clashing regimes over use of marine genetic resources, one that emphasizes, the protection of private use, and the other coming out of the BBNJ that emphasizes the importance of accessibility and use in the benefit of all. And just saying that they should be consistent and mutually supportive doesn't actually resolve any of the clashes to come about use of marine genetic resources. Capacity building and technology transfer is a more settled part of the agreement. There is a remaining question of whether or not states will be required to, in their domestic legal systems, create the conditions that would be favorable for technology transfer on the economic and legal level. There's a lot of issues with environmental impact assessments, that portion of the treaty, some of which I'll cover in the next slides. So I won't talk about them here. Same with area-based management tools. Certainly the relationship with other instruments, frameworks, and bodies and their area-based management tool processes. You know, should the BBNJ endorse those? Should it create standards for those? And then the recurring question of whether there should be special consideration for particular sets of states. On the institutional level, it's not so surprising that there's more unanswered questions here, some of which are particularly important, such as dispute settlement. Will we use the existing system in UNCLOS, or will we essentially recreate that system in a miniature version for the BBNJ to make sure that non-UNCLOS members can use that system but don't feel held to the requirements in UNCLOS? So this is an overview, but these are the 5 areas that I'm going to talk about because they're areas that our work with Rachel and the other Elizabeths and my work with other collaborators have led me to believe that these are major issues of concern in terms of the design of the treaty. And these are also areas where I'm hopeful and somewhat expectant that the debate will be renewed and more nuanced perhaps than it has been in past IGCs. So common heritage, the question comes down to, should it be included in Article 5 general principles and approaches? And as Rachel previewed, the question of common heritage was a lot more animated earlier on. So by our observations, common heritage was mentioned 41 times in IGC 1, and then 56 times in IGC 2. And then we saw a drop off. It was only mentioned 18 times in IGC 3 and only 8 times in IGC 4. But the last round, we heard common heritage discussed 82 times, 82 interventions referred to common heritage. And in the last session concerning Article 5, general principles and approaches, every single developed country that spoke argued against the inclusion of common heritage in Article 5, general principles and approaches. And some of them suggested, well, it could just be in the preamble instead. So this is a recurring debate. And it's not just about the treaty that we want, but it's also about what we've already committed to and the ideology that we want to bring in terms of treaty interpretation once the BBNJ is finalized. I think the G77 has a very strong argument for the inclusion of common heritage of mankind. And so this is a little bit more advocacy editorializing than maybe we usually do in our publications. But we do address this in the Shake It Off paper from the perspective of a historical and an ideological debate. I was very distressed that a country that I have a strong affiliation with expressed at IGC 5 the idea that common heritage was not a settled principle of international law. You know, I am simply an academic, but I'm a scholar of UNCLOS. That's my area of expertise, and that statement is false. Ever since the 1970 Declaration of Seabed Principles, common heritage has been considered a part of customary international law by diplomats and also legal scholars. It is the one part of UNCLOS that can never be amended. And just as a reminder, the current number of members of UNCLOS who have formally consented to be bound by the agreement is 168 members of the international community. And even those who have not consented to be bound by UNCLOS, like the United States, for example, it has been determined that it has entered into customary international law. Our best authority is the International Tribunal on the Law of the Sea. And in their advisory opinion from the Seabed Disputes Chamber, Judge Treves does articulate the fact that this has been recognized as custom since the 1970s, when it rapidly entered customary international law and UNCLOS. You see on the right, the reminder that the BBNJ agreement is supposed to be fully consistent with UNCLOS. And so if common heritage is moved to the preamble, if it's lessened as a principle to guide this agreement, that would be a regression from the centrality and the embeddedness within the UNCLOS regime. Some states argue that common heritage just applies to mineral resources, but the history of the UNCLOS negotiations suggests that that's not the case. It was a purposeful choice in Article 136 to say that the area and its resources, not and its mineral resources, are common heritage of mankind. The fact that the rest of Part 11 focuses on minerals and mining is a product of the fact that at that time, that's what we thought was down there in terms of resources that could be commodified, that could create products that are useful, etc. I would also just note that in other parts of the UNCLOS regime, specifically the extended continental shelf. When there's creatures involved, sedentary species in this case, that are kind of at that interface between the water column, which is freedom of the seas, and the area, which is common heritage, the creatures that are along that sort of seafloor, they round down to the continental shelf. There's more logic in UNCLOS that suggests that even the living resources along the seafloor should round down to the area as opposed to round up to the high seas. And frankly, freedom of the seas has very little conservation value. It has a long legacy. It is also deeply embedded in the UNCLOS regime ever since the 1600s. But that principle emerged in a previous era where we didn't have an understanding that we could impact the ABNJ in this significant way. And it was developed with navigation and fishing in mind, not all these other uses. And so I would argue that not only is common heritage settled international law that we've already committed to, that based on the precedent of UNCLOS should apply to marine genetic resources, but it's the principle that we need for 21st century issues. And I don't think we should expect the G77 to give up on this point. And one of the things that has frustrated me is that the G77 in IGC5 seemed to cede a lot of ground to the developed states who are making assertions about the history of UNCLOS that, in my opinion, were not accurate. And so I hope that the G77 takes the longer view and reminds the developed world that the inclusion of common heritage was part of this grand bargain in UNCLOS. And what the developed world got in exchange was navigational freedoms, transit passage through international straits, high seas navigational freedoms in the exclusive economic zone. This was part of a big trade. And so the G77 held up their end, allowing freedom of navigation to be part of UNCLOS. And so, is the developed world no longer holding up their end when it comes to common heritage? And the first implementing agreement, the Part 11 agreement that modified the rules on seabed mining, already involves substantial concessions on common heritage. It eliminated things like mandatory technology transfer, production controls, et cetera. And so the G77 has already walked back on common heritage. So, we need to hold the line is kind of my thought on the inclusion of this principle. Scientific and technical body. Going through the draft treaty, we are assigning this body a lot of functions related to all areas of the package agreement, but it has essentially no decision-making authority beyond recommendations to the COP or recommendations to states. And so I'm asking myself this question: can the scientific and technical body, whose kind of role is to ensure that scientific information is used in the right ways and relied upon for decision-making, can it do that without being empowered with any particular decision-making authority? And so I have 2 points I want to share on this. And I think we've lost Rachel. Goodbye, Rachel. First, I want to thank my collaborator, Rebecca Helm, who's a high seas ecologist at Georgetown, for a lot of these insights. I think we're all aware that scientific data beyond national jurisdiction is very limited. It's clear we've agreed upon it in the World Ocean Assessment put out by the United Nations. And that scientific data is highly uneven. We know a lot more about the North Atlantic than we do about the Indian Ocean, for example. The BBNJ does not create any mandates for new scientific data collection. The scientific and technical body is not empowered to do or fund data collection. States are not required to collect any more data than they are already. The standard across the board is use the best available science and scientific information. There's no requirement to make what's available better. It's just use what we got, the best that we've got. The problem is we don't know that much about areas beyond national jurisdiction, especially high seas ecosystems. And so Dr. Helm and I are sort of working out this argument that given the really low amount of scientific information, that the EIA process as written in the BBNJ agreement in the draft text is likely to be dysfunctional. Dysfunctional meaning not achieving the intended outcomes of the agreement. So either EIAs are conducted with low evidentiary standards about the nature of high seas ecosystems and potential impacts, in which case they won't be very good at predicting or preventing harm to those ecosystems, or EIAs will hold a high evidentiary standard, and it's likely to take decades for EIAs to actually be conducted, because first you have to collect the baseline data, longitudinal data will be required, multiple sampling at multiple sites, understanding of the relationship between ecosystems and circulation patterns. There's a lot to it. That is not an intended consequence of the BBNJ, because we want sustainable use as well as conservation. And I think there's a risk that if the evidentiary standards are high, that because the BBNJ allows other EIA processes and other bodies to continue independently, that there's a risk that high seas users will be incentivized to look for the forum that has low evidentiary standards that allows them to authorize activities. A second concern about that scientific and technical body, being not empowered when it comes to scientific research, concerns the desire to have some kind of coherence or connection between different EIA proposals or EIA processes and different area-based management tool proposals. So there's two places in the BBNJ treaty where our goal requires coherence. The first is in area-based management tools. We want a representative network that is comprehensive. I don't think the BBNJ treaty we've designed can achieve this, because it creates a process where area-based management tools, marine protected areas, are created in an ad hoc fashion. States propose them and they are designated one at a time. States also have a wide range of criteria in Annex 1 to choose from. On one hand, you could make a proposal based on areas that are especially vulnerable, sensitive, fragile, or you could make a proposal based on areas that are especially productive, viable, have sustainable production. So either weaker areas or stronger areas. So the criteria themselves don't really promote coordination. And of course, it's going to be a lot easier to collect data and make a proposal for the North Atlantic compared to the Indian Ocean, because there's much more baseline data there. Given these facts about what we already know about the ocean and the design of the treaty, there's no ability baked into this treaty design to have this coordination that would lead to a representative, well-connected network. Another area where we want coherence is EIAs. This part of the treaty text is not quite as settled. There's a lot of brackets still, but many of the options would allow states to make the call on the screening phase, on if the harms are larger than anticipated. States make the call about what to do. The idea of the scientific and technical body creating standards that apply to all states is extremely controversial, and it seems unlikely to make it into the final treaty, except for maybe recommendation of guidelines. And so the treaty we're kind of moving towards would again have state-led processes using state design standards that would not meet a common standard. And this is especially concerning to me because of the issue of cumulative impacts, things like ocean acidification, climate change, sort of systemic forms of degradation. There's very different ways that states could deal with that in their EIA processes. And without some common standard for how that should be incorporated, there's strong incentives for states to incorporate them in kind of weak and light ways that overlook the addition of those impacts to the impact of the activity itself. So the scientific and technical body is supposed to promote coordination, but it's not particularly empowered to coordinate. And it's supposed to promote research, but it's not empowered to do research or create requirements for research. My last point is on liability. It's likely that these rules are going to be broken by private actors, by state actors. And just as a reminder, areas beyond national jurisdiction are the most challenging case for enforcement of rules. The ABNJ environment is very vast, it's distant from shorelines, monitoring and surveillance is very difficult. And of course, you have the problems of flags of convenience, shell corporations, as just sort of opacity in the legal and political systems that are designed to regulate this area. So enforcement and liability is very likely to be a problem in the coming decades. UNCLOS requires us to develop the liability regime. This is Article 235 of UNCLOS. If you look at paragraph 3, states are supposed to cooperate in the further development of international law related to responsibility and liability. And they must ensure domestically that there are systems for prompt and adequate compensation. This BBNJ draft agreement is not doing that. There's no specific provision on liability. There's no general provision on liability that would apply to multiple parts. And some of what I've heard in kind of back channel discussions just repeats parts of UNCLOS, paragraph 1, that just says states will be held liable. Hopefully today, I will be able to send you a link to this new marine policy article with my collaborator, Khalil Hassan Ali, writing in his capacity as an UNCLOS scholar, not as a delegate to the BBNJ, where we forward this argument that UNCLOS requires us to further develop the liability measures. But we also look to liability schemes in other areas of ocean governance, especially related to shipping. And we suggest kind of 4 different areas that the BBNJ could help develop the liability regime. And so I know I'm close on time here. So I want to say that it would involve states having to have domestic systems to enhance the legibility and traceability of the private actors under their control and jurisdiction. We don't want to make it so those actors can hide. If states are worried that they will be held liable to the misdeeds of the private actors under their control and jurisdiction, they will be incentivized to create more traceability between them and their private actors. The IMO, the International Maritime Organization, has existing models for a compensation fund specific to environmental harm and damage, one of which assesses contributions from the relevant industry. And if that's not enough, there could be an assessed contribution fund from BBNJ members to kind of cover the difference. Critically, though, one of the problems with the UNCLOS rules on responsibility and liability is that it's really, really hard to prove that you, the actor that's making a claim for compensation, were actually harmed by what happened. And that's much harder out in the areas beyond national jurisdiction. So the BBNJ agreement would need to clarify who can claim compensation. And of course, it would include actors who their own interests were damaged, but also actors who spent money to remediate the harm caused in the ABNJ, and potentially actors suing on behalf of the international community to say that money needs to be paid into these group funds, not to us, but for everyone. So this was Rachel's slide, so I don't know what she wanted to say. Probably not what I'm going to say now, which is that it really bothers me that we call this a high seas treaty. And my opinion is that this is branding, or my perception is that this is branding coming out of non-governmental organizations, because the high seas is a freedom of the seas area. The freedom of the seas principle underlines the high seas regime in UNCLOS. But the areas beyond national jurisdiction also include the area, the international seabed, which is the common heritage of mankind. And I think this framing is part of the reason why common heritage, why the International Seabed Authority and overlap and connection between the BBNJ and the ISA have really been kind of submerged and overlooked in terms of their central relevance to designing this treaty. We knew we were going to be asked if we think a treaty is coming. So we just pre-put our answers on this slide. Rachel's optimistic, I'm pessimistic. I'm worried about the treaty design. So I know people have their own thoughts about that, and I know I've gone over the time I was supposed to anyway. So I'll leave it there and look forward to questions and discussion.
Well, thanks so much, Beth, and also thanks to Rachel, who unfortunately had to leave a little bit early today. We will have a brief input by Sylvia to discuss and to kick off our discussion with the audience today. So you can already get your questions ready. I'm sure there were some things that were mentioned where you woke up a little bit and said, hey, I have a question on this, or I do not agree with this, or yes, I see a few people in the audience that might have something to say. But first we will give the floor to Sylvia. I will briefly introduce you to her, and then we will go to your questions that you can post in the chat, or you can also raise your hand and ask in the audience. So Sylvia has a master in political science from the University of Vienna and a bachelor degree from law from the Metropolitan University of Caracas, Venezuela. She is now PhD student at the Department of Political Science at the University of Vienna, and is on a Soviet Fellowship. And she stays closely connected to the Maripodata project, with her PhD focusing on the rule of knowledge, on the in-person as well as digital multilateral spaces, of the Convention on Biological Diversity and the BBNJ negotiations with regards to marine special closures. So I will hand over to Sylvia and look forward to the discussion with you all. Thanks.
Hi, thank you, Ina. Can you all hear me? Great. Okay, so thank you very much for the introduction and for the presentation. And I have actually more questions than actual comments. So I'm just gonna throw some of them at the moment. So I think it was really interesting, particularly the paper on liability. I liked it very much. And then connecting this paper with the other, I thought since references to common heritage of mankind have decreased throughout the IGCs, but increased considerably in IGC 5, and that liability has also decreased, could it be possible that this has happened first because of a trade-off between MGRs and common heritage of mankind, or some kind of trade-offs between global north and global south states, that the common heritage of mankind was decreasing in references, or that states are trying to pursue liability, like global south states are trying to pursue liability through the common heritage of mankind. Because according to Article 139 of UNCLOS, there is liability when harm is caused to the area. So maybe that's why they have decreased mentioning the liability issue, because they are trying to pursue it through the common heritage of mankind. And then also with another question, since the common heritage of mankind is customary international law, if the BBNJ adopts this interpretation or like lacks to put in practice the common heritage of mankind, wouldn't that make the BBNJ treaty flawed and illegitimate, and then not something that we can rely on, and that it should not be put into practice? And then with regards to liability, so I understood from your article that so far the actor who's making a claim for compensation has to prove the causality between the state's failure to act and the private actor that caused harm. But would it be possible, only theoretically, to reverse this and to, instead of proving the causality, disproving the causality? So like the state who has jurisdiction or control over the private states that caused harm has to disprove the causality between its failure to act and the caused harm. I think that way states would be really keen to prove that they didn't do wrong, and that then they don't have to pay. And this could also increase states' how can I say, interest in raising some funds for paying for eventual damage. So I understand that politically that could be difficult, very difficult, but only theoretically through legal means if this is a possibility. And that is for the moment.
Do you want me to respond now?
Yes, so you can respond straight away, and then we open the floor for other questions.
I was quickly flipping to my UNCLOS. I'm sure we all have copies of UNCLOS right in front of us, right? We should at the BBNJ. Thank you very much for those comments. Really interesting. I'll provide some answers. So the question about common heritage references have decreased. Liability focus has decreased. Are there possible connections or trade-offs? Maybe is the G77 pursuing liability through the inclusion of common heritage? The decrease in references is in part a mystery why the G77 in particular has not continued to push for liability, which they were committed to in their ministerial declarations, and which we saw examples of early in the PrepCom process and around IGC1. that is kind of an internal political question, I think, among the coalition. But in terms of common heritage, I think it's choices of the negotiation leadership about what they put on the agenda for each day. That in IGC 3 and 4, common heritage was sort of avoided because it was seen as a hot button issue. And so it's kind of saved to the last because it's such an ideological, polarized dispute. I don't think liability is being pursued through common heritage. Common heritage is a principle, and liability will require particular rules and procedures. They're just different kinds of things. And so common heritage, the key question is where it is included in the treaty. Is it recognized as a core principle? Whereas liability, we need a little more detailed articulation of what it looks like in terms of implementation and when violations happen after the fact. It is the case that there is a set of liability rules being created and coming out of the International Seabed Authority. And so that is sort of associated with the common heritage. That's another reason why we need a better articulated liability scheme in the BBNJ, because they are being developed on a sectoral basis from existing instruments, frameworks, and bodies. And it's just one more area where we risk incoherence if the BBNJ doesn't adopt some standard that states working through other instruments, frameworks, and bodies can kind of implement to make sure that there's coordination and connection there. Your point about if we don't include common heritage, would that make the BBNJ illegitimate? First, I want to say that there might be members of this audience, but there's certainly people in the room at IGC 5 that strongly disagree with my statement that the common heritage is settled international law. So I think that this debate is happening kind of on the narrative conceptual level, and that claim and that explanation that it is settled international law needs to be made strongly before we can even engage this question of would the BBNJ be illegitimate without it. I was flipping through UNCLOS to get the exact text, but part of common heritage not being amendable is that states cannot make other agreements that derogate common heritage of mankind. You know, that's a requirement under UNCLOS. So theoretically, Sylvia, yes, that would make it illegitimate as part of the ocean governance regime. But like I sort of was saying, there have been steps back from common heritage in the 80s and 90s and 2000s. And so for me, the question is not just defending, hey, let's not restrict this more, but let's be fully consistent with UNCLOS. And all this walking back we've done, let's walk forward in the direction that we all committed to 50 years ago. The question about flipping the burden of proof for liability, love the idea, totally politically impossible in my mind. States would never agree with that. But I did forget one thing that might be a key element and is in the text of UNCLOS, which is compulsory insurance. So in addition to setting up these two potential forms of funds, in addition to requiring states to better legally articulate that relationship of jurisdiction and control, if users of ABNJ are required to have compulsory insurance, then when we're talking about who has standing to sue, it could be a state actor suing an insurance company that was insured the private actor to get compensation when the private actor violated the terms of the BBNJ agreement. So this situation we're in now, where liability only happens, or states are only liable if they violated their responsibility to implement the rules and that caused the harm and damage. There's been almost no instance of that actually resulting in compensation for harm and damage, because the chains of causality are so difficult to prove, even more so in areas beyond national jurisdiction. So the system we have is not going to work for the system we want. We need something better, and UNCLOS requires us to have something better. And so this one last point here, this is one of the examples of why I'm concerned about having a treaty, 2.5 weeks from now, having a finalized treaty, because this would require creating a whole new provision in the draft treaty. There's no draft article to work with here. But if we don't get this, my fear is that treaty violations will just go unchecked. So that's why I'm so fired up about it. Thanks.
Yes, thanks. That's already spurring quite a debate, I think, in the audience also. We see Khalil also being part of the audience, so feel free to jump in whenever you feel that is necessary. We have one question already. I cannot completely identify who that is, so please identify yourself and you can ask your question. And you can also feel free, everybody, you can turn on your cameras if your internet allows, so we have more of a informal space to discuss these issues. And I hand over to the one who's raising your hand, Aitli.
Hi, I'm sorry, I didn't realize. So my name is Aiste. Yeah, I should have updated the name. I wanted to thank for this really fascinating presentation, and there are so many questions that one could ask. And I believe Beth mentioned she didn't find the exact quote about the common heritage. So it's in front of me, I can read it. It says, state parties agree that there shall be no amendments to the basic principle relating to the common heritage of mankind set forth in Article 136, and that they shall not be party to any agreement in derogation thereof. So yeah, I think it's very clear. And the presentations were actually very clear, but I might have missed something. I'm not really connected directly to the law of the sea, and I'm really curious if there is a case, so which international court would take this case? Because to my understanding, current international courts are connected to, human, cases. So if you are not a human, if you are I don't know, an animal in the sea, which court would take your case? How would that work? I might have missed it, but I'm really curious, because if we are talking about basically this whole treaty somehow should have some sort of very concrete outcome at the end if something happens. So I was just interested, how does that work in practice? Does it work at all? Thank you.
Yeah, thanks for the question. So the relevant reference is Article 55 in the draft treaty, which is under Part 9, settlement of disputes. And right now, the BBNJ delegates are contemplating two basic options, or there's two options written into the draft text. The first is essentially using what we already have in UNCLOS Part 15. And UNCLOS is actually pretty radical in terms of the system of dispute settlement. It was a major advance on what we had before, in part because dispute settlement is compulsory, with a few critical exceptions like maritime boundary delimitation. But in general, it's compulsory. It's required to settle your disputes. And negotiation is always an option, but UNCLOS created or enshrined three other options: the International Court of Justice, which has broad subject area jurisdiction; the International Tribunal on the Law of the Sea, created in 1996, so Law of the Sea specific jurisdiction, and arbitration, an arbitral tribunal that could be set up ad hoc in the case of the dispute. And so either the BBNJ agreement will basically refer to and utilize this pre-existing system, or option two is like a miniature version of that system, which would also allow for arbitration, also allow for those other courts. But with one exception of the International Seabed Authority and the Seabed Disputes Chamber, which is like a special thing in the Tribunal of the Law of the Sea, these would be states bringing cases against one another. And in the case of environmental protection, there are at least two examples related to transboundary pollution that have had some positive outcomes. So this system has been used a little to deal with environmental impacts in areas within national jurisdiction. But if you were going to bring a case against a private actor, that would have to occur within the framework of a domestic legal system, but recall though that the BBNJ could have requirements for domestication of a legal system for liability, which is required by UNCLOS. Article 235, paragraph 2 is you got to domesticate this system to basically make sure the money will be there. So when you're talking about private actors, you have to have the state's domestic legal system involved. But many of these actors doing areas beyond national jurisdiction activities might be states themselves or state representatives. And so in that case, going directly to the dispute settlement system might make sense. So I hope that answers your question. In general, it's like there's multiple options. You have to settle disputes. But if we want dispute settlement to work when private actors violate the rules and cause damage or harm to the marine environment, we need to articulate a more precise structure for liability that kind of clarifies what that relationship between the state and the private actor is supposed to be in these circumstances.
Thanks so much. So next in the line is Bob.
Yes, yeah, thank you so much for organizing this webinar. My name is Bob Krijken. I'm a PhD researcher at Delft University of Technology, focusing on the responsible digitization of biodiversity, with a specific focus on DSI in the CBD. I'd like to touch upon the chart about this, the map, and the point that there's much more data on the North Atlantic than on the South Atlantic. And therefore, I wonder what legal instruments could help to incentivize the collection of data in the, let's say, in the global South, if you can call it, and incentivize also the sharing of data that is collected in that region. So a legal instrument that focuses on capacity building and the sharing of data. Maybe some of you can give me some ideas about that. Thank you.
Thanks for the question. And also, you know, this audience is full of experts. So I'm the one in the hot seat to answer the questions, but I'd be really interested to hear other people's answers to these kinds of questions too. Having an international agreement that mandates scientific data collection or funds scientific data collection is extremely unusual. And so that is why, you know, it's kind of like, how would this work? What would this look like? In my opinion, though, in the 21st century, given the scale of environmental problems we face and the nature of those problems, and the areas where those problems are, namely away from national jurisdiction, we shouldn't and we can't be satisfied with the best available scientific evidence, because sometimes the best available is very little. So for example, and this, I need to credit Rebecca Helm again for this example, high seas ecologist from Georgetown. An environmental impact assessment was done through the Netherlands legal system. So it's a domestic EIA process for the ocean cleanup project, you know, trawling out plastic in the high seas. And one of the questions was, how would it affect these Neuston ecosystems, these kind of sea surface, free-floating creatures? And the scientific data was so poor that the estimate for the project was either it will have a negligible impact on these creatures, or it may 100% eliminate the ecosystem. Like, that is how wide the range of estimates was. So best available is not going to be good enough to achieve the goals of the BBNJ. And so what this could look like in a BBNJ agreement, and frankly, I'm not optimistic because this is so unusual, is it's possible that the scientific and technical body could create some sort of thresholds or standards, you know, a point that you have to cross in terms of type or amount of data. And I'm a political scientist, so I'm not the one to answer this question. But in terms of perhaps longitudinal data or understanding of reproduction processes, it's possible that a standard could be created that if you don't have data that meets this standard, you don't have enough to do an EIA. And so that the scientific and technical body could create that standard, and arguably the BBNJ could impose that standard. So that would create incentives for proponents of MPAs to do that data collection. It is also theoretically possible that some of these assessed contributions for the BBNJ could be put into a fund to fund marine scientific research. You know, it could be a grant-based program. Arguably, a scientific body could be created. But we've seen this in the International Seabed Authority. One of its secondary mandates is to promote marine scientific research, but they're not doing any research themselves. They're not funding research directly. And so we've seen this wiggle room where it's just promote research, promote dissemination of findings. That's not actually a mandate to directly fund or do research. And so I think we would need a two-pronged system, one that either incentivizes or perhaps requires states, if they want to do stuff in the ABNJ, they want to conduct EIAs, proposed marine protected areas, to collect the certain types of scientific data, or perhaps to fund scientific research projects at a certain level. And then a second prong where the STB or another body created by the BBNJ has some mandate to in some way pursue, not just promote, but pursue marine scientific research. And frankly, I just don't get it. Nobody's talking about how EIAs will actually work given the paucity of environmental data and areas beyond national jurisdiction. It's just kind of assumed that, of course, EIAs will be conducted and they'll be fine and there will be good science, but the best available science out there is really, really not good. Thanks for the question.
Yeah, thank you.
Chat also.
Thanks so much. We have one question in the chat about your best case scenario. So what's your hope for the next IGC?
Of course, I don't want to postpone for years and years and years. I'm not saying that we should delay or we should drag things out. But what I felt at IGC 5 was that there was so much emphasis on the need to complete a treaty that there was not very much attention to the need to design a good treaty that will work. And so I'm really just trying to push back on the urgency to finalize quickly because I'm worried about the design. And then also because there were all kinds of equity issues at IGC 5 where developing countries and especially the coalitions were like, we cannot keep up. We don't have enough delegates to send to all these small homework groups. And we don't have time to meet in our coalitions. And so what I have perceived is that some of the recent movement in the draft text is a result of moving so fast that the developing country coalitions, especially the G77, but also the regional coalitions, can't catch up in terms of coordinating among themselves. And this is a problem at the negotiations, but it's also a problem in this preparatory phase. I have heard multiple times from delegates from developing countries that they want to schedule a meeting to coordinate among themselves on an issue, but the High Seas Alliance has already filled the calendar with workshops in those 3 or 4 days just before the negotiations that people have already committed to. There's kind of, at the negotiations, there's a tension between what the leadership has put on the agenda and what the coalitions need to do, internally to get their positions together to draft text. I have also perceived, and I'm not directly a part of this, so I'm sure there's others in the audience who could say, with more direct knowledge, that there's a tension between the coordinating efforts by NGOs and the desire for coordinating efforts by the coalitions themselves. So I think maybe an IG6 will be called for. I mean, we'll see what compromises come to the fore. But what I fear about this urgency is my last point, but 2 things. Number one, we want to get a treaty so bad, in part because we want to feel good about it. We want to pat ourselves in the back for what we contributed to getting something done. And there's going to be a lot of celebration when this is done, and rightly so. But I hope we can celebrate because the treaty is good, not just because it's done. And secondly, there's a lot of text being drafted now, or, draft texts that have been drafted are going to be proposed. And it seems to me like there's almost pre-compromising happening, that states are thinking, well, we won't have time to really flesh out the rule that we want, that we think would be best. So let's draft something and propose something that's a lot simpler and more acceptable because we only have 2 weeks to get everyone to agree. So there's kind of a pre-watering down because of the urgency that everyone feels. So I hope that it's done in 2023. Maybe we'll have a good treaty and 2.5 weeks from now, but I just think that we shouldn't make a done treaty the enemy of a good treaty.
Thanks so much. I'm going to throw in some questions while you are drafting your app. We have another one by Sylvia, and then I'll have some more on unresolved issues as well as missing issues in the treaty. Sylvia.
Okay, thank you. Regarding this issue of attention between NGOs and coalitions, I see not exactly between NGOs and coalitions, the same issue in the CBD, but I would say between, I guess, the bureau and the states. The same issue happens that they have, in a COP, you can have like 6 meetings happening at the same time. And if you have a delegation of 2 people, how do you cover those meetings? Or you have you split marine issues into meetings when in the CBD marine experts are minorities. So I think like how are states actually dealing with these issues? So what solution would you suggest besides giving more time? I mean, this is also an issue of funding, of how many states are subsidized to actually attend the meetings in person, how many delegates can meet them in person. But what beyond that, what would you suggest to improve this situation, not only in BBNJ, but in other fora?
Yeah, well, thanks for the comments and the question. I personally have my thoughts, but I don't need to make suggestions because developing countries have already been telling us what they need and what they want. And bottom line, it's fewer parallel sessions. Because the EU is always going to have enough people to cover every session, probably a team at every session. But the voluntary trust fund that has brought, for example, small island developing states has limitations in terms of the number of people that can come. And so more contributions to the voluntary trust fund, fewer parallel sessions. And then also there is this phenomena of NGOs or academics or independent scholars supporting smaller delegations and enhancing their own capacity. So it's something that we, meaning like the community that I'm a part of scholars that are not associated with the delegation, can do. But I see some limitations to that. First, that there's not that many UNCLOS scholars involved. As I said, I was really distraught to hear the debate about what UNCLOS does and does not say, the history of the UNCLOS negotiations. I just felt like, wow, there's not that much expertise in this room, as much as you would expect on the history of the law of the sea. But then also, if I were to, for example, support a small island developing state in a parallel session or formulating a draft text, that's all well and good. I think that I have good values and I think that I'm smart and I know the law of the sea, but I don't know that state and its people. And I'm not going to feel their national interests the same way that representatives from that state will feel those interests. So that is not a perfect solution. That's one way to help, but that's not nearly enough. So slow down, fewer parallel sessions, more funding. That's what they're asking for, and that's what we need.
Thanks. I will just throw in some further topics, unless there are any other questions from your side. So one would be on, so you mentioned missing things in the draft or something that you would want to see, which is the liability. There's also something that I would want to see, but I don't know if that's going to happen. We will have a bit of a block series coming out soon with numerical data. So what do you think about extending the humankind to further than humans? So in the GBF, Global Biodiversity Framework, there's already the mentioning of the value of nature beyond economic benefit, beyond benefits to humans. So looking into the conservation and protection of the ocean, also including benefits to not only humans, but also the planet as a whole. Has that come up in your research or in the discussions? And what is your thought on that?
Well, it's certainly come up in my dreams, meaning like the ideal future vision for me. I'm totally on board with expanding the legal representation of non-anthropocentric values. But I think that, again, it's a non-starter. I feel this tension, like I'm asking for a lot from this treaty. There are a lot of ways I'm dissatisfied, but at the same time, I'm trying to hold myself within the realm of political feasibility. And I just don't think that the world is ready for a common heritage of all life, for example. But I do think there are places where we can better represent the environmental values that we've already committed to. So for example, UNCLOS Article 192, all states are obligated to preserve and protect the marine environment, including beyond national jurisdiction. Well, on these smaller issues, like the question of standing, who has standing to bring a claim for compensation in the case of damage or harm, a lot of the focus has been on harm to specific actors and their specific interests. But if the BBNJ agreement includes a liability mechanism that allows states to have standing to sue or make a claim when there's just damage to the marine environment, not harm to their interests, but just damage to the environment, then that is a reflection of the idea that the environment itself has value and that we should create mechanisms or architecture that represents that value, reflects it, and requires us to do something when that value is damaged. So I think I'm like trying to look for creative ways that we can serve the interest, non-anthropocentric interest. But right now, a lot of the debate is between human-focused conservation, environmental protection values versus sectors, profits, private actors, more parochial interests. And we're at this like private versus public, parochial versus shared. We're not ready to go to that next phase of how much should we be sharing in terms of, moral obligations beyond humans. But personally, I'm on board. I'd vote for that for sure.
Perfect. Thanks so much. Samantha.
Hi, can you hear me? Thanks, it was a really interesting presentation. I'm currently a legal researcher at the Royal Netherlands Institute for Sea Research, working on a project looking at protecting hydrothermal vents through area-based management tools. So I was really interested in what you said about the treaty having a lack of coherence when it comes to area-based management tools and like the networks they would create. And specifically, you said something about the criteria that's listed in Annex 1 being too wide. And I was just interested by that because my initial thought would be that wider criteria would be better because it means there are more ways that you could create a tool that protects the marine environment. So I was just wondering if you could expand on that and maybe give your thoughts on how the draft text could be improved to be better, like to promote better coherence among area-based management tools.
Yeah, thanks for the question. So we're talking about Annex 1, the criteria for identifying areas for protection, and we've got A through V here. And my understanding is that this list was sort of compiled out of the ecologically and biologically sensitive areas list, vulnerable marine areas, maybe a little bit of particularly sensitive sea areas from the IMO. So there's other lists out there that were drawn on to create this list. And you're right that it is broad, and that's good because there's multiple ways that you can justify a protected area. I wouldn't say it's too wide. I would say the problem is that it's so wide that it's such a grab bag that it makes it so there's more options for how you justify your MPA. And that's only an issue for creating a comprehensive representative network of MPAs. Because what if all we get is everyone is trying to protect the most sensitive and fragile areas, and no one is making proposals based on more resilient, more productive, more viable areas? In that case, we won't end up with a representative network. I think we need some body, scientific and technical body, to be empowered to say, listen, we've gotten 15 proposals that use criteria A through K, but we're really lacking proposals on criteria L through V, and that's what we need. So we're going to prioritize those proposals. So a wide, broad list is good, but if you're trying to use that to maximum effect to create a coherent, comprehensive, effective, representative network, there needs to be some view from the top that's guiding our different use that says, listen, there's an emphasis here and we need to spread out and emphasize here too. And this BBNJ treaty design just doesn't have room for that. So I like a big list. It's just a question of how we use it.
Perfect. I had one more question to you, Beth, on the unresolved issues regarding environmental impact assessments. So you did not mention the threshold issue, and you did not mention the decision-making on authorizing activities. Why is that?
Well, are you talking about those in relation to the question of internationalization? Yeah. Why not? Because it was too big a can of worms for the amount of time that I had. Also, I think that Khalil's other scholarly work addresses this really well. So I don't really consider it my area of expertise, but I was trying to get that a little bit in the overview of remaining issues slide, because I do think that the EIA's issue area has a lot of the unresolved contentious issues. But I do think that this connects to the question of coherence and standardization, because internationalization could be internationalized decision-making, like for a particular screening process or for authorizing an activity, or crucially, when an activity has been authorized and the harm is more than we expected, or they violated the terms of the EIA, then who decides what happens? So decision-making at an international level, or at the international level, the creation of standards, guidance, and guidelines that then individual states have to use in their decision-making on those three issues. And both of those options are a tool for creating coherence in the process. So I was trying to get at it from that angle of at what level decision-making is, and what can the STB do that could promote coordination coherence. But yeah, I already have the problem of talking for too long. So that's why I didn't take it on. Not because I don't think it's not important or won't be contentious.
Sylvia.
Yeah, thank you. Going back to Ina's questions regarding the common heritage of humankind, and regarding how we can improve the treaty. What about linking the common heritage of humankind to the section of AVMTs and MPAs and EIAs? Because I think this could enhance the potential of the common heritage of mankind as a conservation tool, like Ina has said. And at the same time, I'm just going to throw this there and see what people think about it. But I don't think that the common heritage of mankind would introduce non-anthropocentric views about nature in this issue, because it says basically we protect it for our own good, not for the good of nature as such. So I think, anyway, it's a good start, but I think much more work will have to be done in future BBNJ COPs to actually introduce non-anthropocentric views. So yeah, just what does the floor say? That's really what I want to get at.
Absolutely, it's not common heritage of all life. And honestly, can we just write humankind in the treaty? Everyone's saying common heritage of humankind. There's no reason we need to continue saying mankind. We know they mean the same thing. Maybe that's a treaty drafting issue, but that's why I'm trying to say common heritage, because I don't like this unnecessary gendered language. Anyway, so the question about linking the principle in the particular package areas, if I recall correctly, in previous draft texts, the section, the different parts on the different issue areas, they all start with an objective section. And common heritage, the debates were kind of happening there, but across the treaty. And so the idea was that moving it to general principles and approaches, like we could deal with it once there, that would apply to the rest of the treaty. And I think that in terms of the text saying common heritage, I think it's most appropriate in general principles and approaches, because that's what it is. It's a principle that represents the basic goals, values, and purposes of the agreement. But in each of the issue areas, that's where the principle is translated into rules and norms that fulfill or satisfy or reflect that principle. And so there are examples throughout where if you were going to commit to a common heritage principle, which again, we already committed to in UNCLOS, then that kind of suggests which decisions are better supported or more consistent with that principle throughout the treaty. So for example, one of the still bracketed areas in the MGR section is should utilization be for the purposes of, and it goes on, but basically it's like all humans, benefits to be shared, etc. So that would be an example of a specific rule that would reflect that more general principle. I think it could also be reflected in these points about scientific asymmetry or scientific data asymmetry and scientific data collection. How equitable is it if it's easier to propose MPAs in the North Atlantic than the Indian Ocean because of asymmetries in scientific data availability? Not only might it be an equity issue, but it's not really treating the full ocean as the common heritage of all of us. And so there are lots of different examples where common heritage could be better reflected in the rules. And I want to say that common heritage, it's not defined in UNCLOS, but the consensus is that it has 5 main elements: no sovereignty claims, peaceful purposes, cooperative management, so cooperative decision-making, which suggests internationalization in places like EIAs, equitable benefit sharing, of course, and protection of the environment for future generations. So those are the 5 things that we would want to see reflected in the rules throughout these different package areas. Yeah.
And we have a final question in the room. Aiste, I think was.
Yeah, thank you. So just a quick question connected to what Sylvia said, I guess. UNCLOS was negotiated and kind of imagined in the 70s, and today we're in 2023. So maybe quite broad question, but how realistic it is to bring these ideas from long time ago up to date, like you mentioned, gendered language, anthropocentrism, all of the issues. I mean, we're still living kind of on the ideas of the 70s when we thought that the deep sea is basically a desert. Today we know it's not. So maybe just too broad of a question, but just kind of hoping that there is some sort of way forward to not be so outdated. And respecting the law in itself. I mean, there is a lot of meaning why it's there and shouldn't be amended, but at the same time, it's really outdated. Yeah, thank you.
Yeah, it's the best worst treaty we've got. The thing is, we're stuck with UNCLOS, and that's difficult because of the way that 1970s assumptions are built into it. An assumption, for example, that the only resource of value in the deep sea are minerals. Like, we know that that's no longer true. So we need to make sure that the rules we have apply to the broader set of resources down there. So it's a challenge, but it's also a really good thing, because most of the international community, 167 states plus the EU, have consented to be bound by it. And most of the states that haven't ratified are landlocked, or the United States, or a few others. But we have to use that because we've already invested in it, we've already agreed to it, but also because the BBNJ is the 3rd implementing agreement to UNCLOS. And we've formally committed in the UN General Assembly resolutions, kind of kicking off the negotiations, describing their mandate, that it has to be fully consistent with UNCLOS. That doesn't mean we have to repeat the mistakes or continue the gaps of UNCLOS. An implementing agreement is one of many different mechanisms that we can use to promote the progressive development of the UNCLOS-centered regime. And so another example of that is the idea of evolutionary terms. So UNCLOS, as far as I'm aware, it doesn't use the word sustainable or sustainability, because that was kind of an early 90s shift in conceptual thinking. It says protection and preservation of the marine environment. Now we're talking about conservation and sustainable use. It's possible, like, one existing mechanism for expanding or modifying or broadening the interpretation of a treaty is to recognize that those treaty terms have evolutionary meaning. There's also dispute settlement. There's also implementing agreements. There's also rulemaking by bodies within the UNCLOS framework, like the Seabed Authority, or new bodies created by the BBNJ, like the Scientific and Technical Body. So there are multiple options for developing this regime in the right directions. And I think that should be our emphasis, rather than creating a whole new freestanding treaty. We can't do that based on the terms of these negotiations. We can't do that based on all the existing governance frameworks, the regional and sectoral bodies that manage the ABNJ. And we shouldn't do that because UNCLOS is already very well subscribed, and we need to take advantage of that. And just as a last point, one of the unresolved issues is the threshold for entry into force of the BBNJ, 30 states or 60 states. The UNCLOS threshold was 60 states, but it took 12 years, right? 82 to 1994 to enter into force. So that's a question for implementation. You know, there's finalizing the treaty text, but then there's entry into force, enough ratifications. But what does it mean if we lower that threshold to just 30 states? Who will those first 30 be, and how many will we get? And can the treaty really work if we only have buy-in by 30 members of the international community? So lots of good and important questions remaining, and I hope to see you all next week.
Yes, so thank you so much, Beth, for taking the time and for everybody else also to join in so shortly before the negotiations. We will have a few more sessions on BBNJ. I will just quickly share my screen to wrap up the session and tell you what's happening next. So we will obviously have a bit of a break over the time of the negotiations, but then we will start straight away with, I hope you can see my screen, the next Miracle Data seminar on the Marine Manager Portal. So basically, Global Fishing Watch talking about how this portal can assist the implementation of the BBNJ agreement. Because at that point, on March 8th, we will probably have the final treaty adopted on the table with the final text. And then we also have a follow-up session in April with an expert panel coming together on how to implement the BBNJ treaty. And in May, we will continue with the politics of marine carbon storage. So for those of you who are on our list, you will get all the information. Those of you who don't, please reach out to us. And yeah, you will hear from us. And I will hand over to Elise for a few last words. And thank you again, Beth, and also to Rachel and everyone to have joined in, and hope to see you in New York. Thank you very much.
Thank you very much, Ina, and also Beth. I think this was really interesting, and it's also great that so many people joined us from all over the world. So really a successful session. Yeah, I would like to wish all of those that travel to New York, yeah, interesting negotiations, and I'm sure we will see or hear from each other soon. And thank you, Ina, for organizing the event. Bye. Have a lovely evening or morning.
Thank you.
Thank you. Bye-bye.